we can't get a couple of answers to some questions that have come in from attendees, and I'd like both of you to give your thoughts on this. I just want to talk a little bit more about Orange Book listed patents. An attendee wanting to know your thoughts on strategic considerations that patent holders should contemplate when facing these challenges through IPR or PGR proceedings concerning their Orange Book listed patents. And we're going to start with Jason, and then Hakoon, your thoughts on that.
So, I think, the concern with Orange Book listings obviously is really an antitrust concern more than anything else. I don't know that the Hatch-Waxman statute offers any major punitive, response if you mislist, and it does say you must list, you shall list. So I think, at best, from an overview point of view, you want to give the issue of whether your patent covers your product enough due diligence that you can say you had a good faith view of listing it. And I think that probably goes a long way in the antitrust realm. I'm not an antitrust lawyer, but I think in almost any legal circumstance, good faith, particularly where you have a statute that is compelling you to list patents, goes a long way. And so if I were on the branded side of things, I would think about it that way. On the generic side of it, I think if you're looking to say a patent was mislisted, that plays into both the category of the statute that it belongs to, but it also plays into whether that claim covers, in fact, the product. And that plays into a whole bunch of discussions about claim construction as well. And so it's almost a mini litigation within a larger Hatch-Waxman litigation. And I think you have to make a decision about whether there's value in arguing that, or whether the cost of engaging in that mini litigation is really worth it. Especially if you think you have a strong case on non-infringement or invalidity, you may just want to resolve that case right there and then.
Excellent. Hakoon, any thoughts from you?
Yeah, I think that from a patent owner perspective, the concern, I think, is also exposure generally. Because generally, I think what we're talking about is overlisting, but what about underlisting? I mean, there's no real penalty to not listing a patent, so long as you have one patent that can trigger the Hatch-Waxman litigation and 30-month stay. So let's say you have a broader platform patent and more specific species patents that has a picture claim for your product. You may decide as a patent holder that you don't want to list the broader patent because you won't want to put it at risk. It is a shall list requirement, but there's no real penalty to not listing other than you are unlikely to get a 30-month stay from it. But since you only get one, as long as you have a patent up there, it doesn't really matter. The other side of this is that by listing those patents, by listing all the patents, you obviously advertise to potential challengers which ones you consider to be important. So they may actually target those to clear the path via IPR or PGR. Because, that's one of the big differences between Hatch-Waxman, small molecule, and biologics, is that from a biologics perspective, if you're a BLA holder, you have no obligation to list your patents anywhere, right? Unless you go through the BPCIA process and you trade those things, then you have to list it in the purple book. But otherwise, there's no proactive requirement to list the patents to cover your product. So you don't advertise to everyone who might be a potential challenger, these are the ones that I think are important. So the same may be true for Orange Book listings. If you go back and you look at your Orange Book listing, strategically, you may say, well, this is a platform patent. It covers more than one product. If I list it here, what's the impact of that being challenged on my other products, even future products, right? So there's a lot of things to keep in mind there. And as we all know, IPRs and PGRs can be particularly challenging for those who own patents because the burden for proving invalidity is much lower. It's a preponderance of the evidence instead of the clear, convincing evidence that you have to prove at litigation. And I like to think of it, and this is not, don't quote me on this, but I like to think of this as the difference between clear and convincing evidence being 70%-ish and then preponderance of evidence being 51%, right? So there's a gap there where you actually have to prove less to invalidate a patent in an IPR or PGR. Now, of course, there's always the question of estoppel. So, that's something you have to deal with. But if you are a generic that you're looking to clear the path, or if you're trying to get some insight as to whether you want to put resources behind filing an ANDA, maybe you take a shot at one of those broader patents because they're going to be broader, they're going to be more subject to invalidity arguments, and you might take that shot early. And maybe you don't even want to win. Maybe what you want to do is bring the other person to the table and negotiate a settlement or a license of some kind to clear the path for you so you have more certainty when you put resources into developing your ANDA product. So there are lots of strategic considerations there, I think, with regard to what you list as a patent owner. There are a lot of strategic considerations from the generic side as to how you read that list. And whether you depend on that being the total list or not. So I think there are definitely things you got to look at there, and they can certainly impact what happens to your product and other products down the line.